After a day of long hearing yesterday, NASA exhausted its 5 hours allocated by the Supreme Court to present its case, in which they alleged a mathematical formula was used for the result of the winner of the presidential election. But when making their responding submissions, IEBC lawyers dismissed the allegations, saying that the will of the people was supreme in the election of August 8th. In studio to break down yesterday's court session and give us a focus of today's hearing are lawyers Martin Law, Collins Mango, and Alutulala, Dr. Alutulala Mukhwana. Welcome, gentlemen, and thank you for joining us this morning. And let me start with you, Doctor, since you're closest to me, Dr. Mukhwana. Maybe just to give us a summary of what has happened so far. We have still 3 days to go before the deadline of when the Supreme Court has to give a ruling. But just break it down simply. We had, there was a lot of English and a lot of terms that the common mwananchi would struggle to understand. But maybe just to give it in a palatable manner, what exactly happened yesterday?
Thank you.
So far.
Thank you, Michael, and thanks again for hosting me and for hosting us. First of all, Michael, before I delve into what you've asked me to do, allow me to make 1 or 2 comments that I think interest me. What happened yesterday at the Supreme Court gates? We witnessed an incident which was not very good.
Where there was an altercation between
Precisely,
yes.
Precisely. The Honorable Prime Minister was getting in with his entourage, plus Honorable Wetangula, and plus Honorable Musalia Mudavadi of ANC. And somehow we do not get to understand what happened, but what we saw on television was a very serious altercation involving the former Prime Minister, and at one stage he was very animated and upset. It then emerges that the security guys were stopping Honorable Wetangula's bodyguard from getting into the precincts of the Supreme Court. My view is this, that whereas the security was prime, it is important that the way our security officers handle such situations is with such decorum that it does not inflame unnecessary passions. This is not the right time when we should have those kinds of altercations, particularly involving none other than the leader of the opposition, whose petition is before the Supreme Court, where he was heading to. If there was a problem in terms of Honorable Wetangula's bodyguard getting into the Supreme Court with a weapon, clearly the security officers knew in advance. And there is a more polite way of doing it, off the cameras. So that should not be done. Number 2, I would like also to comment on the way the Supreme Court, and that will lead me to where you've asked me to go, the way the Supreme Court has handled itself so far. If you realize, Michael, and we said it last time I was here with Michelle, that the current Supreme Court, as currently constituted, is no comparison to the 2013 Supreme Court.
And why is that?
Clear. Number 1, the occupants are different. That's obvious, number 1. And 2, their philosophical dispositions are quite different. I will not go into the details because that will amount to discussing the philosophical disposition of each judge. But one thing that they have done, and personally I'm very happy, and most of us must thank them, that whereas the 2 protagonists have gone to court with the intention of making sure they outdo each other, but most likely some of them appear to be playing to their supporters, and they want to depict a situation where it's either I win or nothing else. And the other side is either they win or nothing else. And so you see the way they began with the interlocutory applications. Now I go to where you have asked me to do. The applications from both sides appeared intent on knocking off the other's application. And the way the Supreme Court has handled so far is superb. Technically, some of the applications ought not to have been allowed.
On time issues and things
Precisely.
like that.
And without going to technicalities, the rule is very simple, that you must file documents in order. Number 1. Number 2, that you must file in time. So on the basis of those 2, both sides argued. The petitioner arguing that, look, IBC, Wafula Chebukati, and Uhuru Kenyatta, you filed your documentation out of time. And therefore, your documentations must not be allowed. And the other side argued vice versa. If the court was to go the strictly technical interpretation...
Which is what happened in 2013.
Precisely. Then most of those pleadings should have been struck off. what the court decided to do, and this they did in their powers, original jurisdiction sui generis in legal terms, and exercising their jurisdiction, and aware of the magnitude of the task ahead of them, they decided to accept all applications out of time, not technically 100% compliant, but they said, hey, let everybody produce what he or she has.
No, I think that if we go that route, and we need to be of help here.
Yes, please.
The Constitution is very clear.
Yes, please.
That when it comes to matters substantive and matters technical,
Yes.
we go to substantive.
Thank you.
So what the Supreme Court did this time round is the right thing to do, because the previous the 2013 Supreme Court was actually slightly below the threshold of the Constitution. So the argument here is, what is substantive? Let that be in. Forget about technicalities. Yes, the one side argued the other sides were not on time, the other said the others were not on time. The court said, forget all of those, bring it on. We want to listen. What's the substance of what you are saying?
Precisely.
And that is the way the Constitution anticipates, that when it comes to grave substantive matters of the law, the courts shall be persuaded by substance rather than technicalities. That is a settled law now.
Precisely. And that is what Michael was trying to compare.
Correct.
That unlike in 2013, the court has had to take that position.
Right.
So in my view, the court has set it very well. The temperatures have come down. And what now is left is to allow the petitioner to prove his case. He had the opportunity yesterday, without delving into the merits and demerits of how he did it. What the petitioners have done is to say, look, the elections were not compliant with the Constitution and the election laws. They have cited a number of grounds, which are now in the public domain, but chief among them, they are saying, number one, Forms 34As, Forms 34Bs, as finally presented to them, some of them were not genuine, they were not accurate, and number two, that the system between the polling center and the final tallying center was not accurate, was not verifiable.
Okay, we'll come to the actual submissions that were made and maybe what was done and also the responses that came. But let me hear from you, Martin Olo, your summary of what has happened so far and your thoughts of possibly even in comparison to 2013 and where we are today.
Basically, what has happened in terms of, again, breaking down for the viewer, is that the petitioner on that deadline day submitted their petition. And some people have said that, well, the case only began the other day. No. As soon as the petition was put in, 14 days began to run. There was the room for service. The respondents had to be served, and they also had to respond. Now that has happened. Now in those responses, you raise both your defense issues and as well as attack the petition. So that has happened. In the process, the court also directed that they move to submit, to make submissions on their main written submissions on the substance of their petition. Those were made and they were submitted, they were filed in court and served to the other parties. But in the process, what the petitioners and the respondents also did is they raised what you call the interlocutory issues, some intervening issues in the interim, trying to say, hey, wait, but these guys have filed this out of time, or we need more information, we need access to the server, and so on. So what the courts have done this time around, what the Supreme Court has done this time around, is to strictly enforce Article 35 of the Constitution, access to information. Any person, any citizen in this country has a right to access information that is in the custody of the state. So that they have underlined by saying, oh, fine, you want to have access to the server, fine, have a look at it, but it will be in the control of the court. Number two, the court has also, rightly so, unlike in 2013, taken the leadership in this case. Because if you leave lawyers on their own, they'll argue until cows come home. Because each of them is trying to do the other. But the court is saying, wait, we're giving you 3 minutes, 3 hours, we're giving you 5 hours, tell us all you need to say. We want access to this, we will give you, but we'll also give you a supervisor. So we give you an ICT officer, go in there, do as the registrar tells you. So you don't leave lawyers on their own to go and argue there and fight over. And they said also that as soon as you've done that, we're giving you so many hours, file your report, And after you have filed a report, you can file submissions of that report. So basically what this court this time has done is manage this process very well and made sure that everybody who needs to be heard has been heard and documentation is in. When it came to ruling on the issues, they went and reasoned it out. They came up with a written ruling on it. And so far, so good. I mean, they are displaying what a Supreme Court ought to be doing. It is the highest apex of the judicial system, and its records and its manner of operation has to be beyond reproach. So I think so far, so
Collins, maybe just to hear your comments on that as well before we move on to what is expected. It seems that the legal counsel you have so far are very happy with Supreme Court. Yourself, what are your feelings?
I can't agree more with my learned senior. We are now seeing a lot of improvement from the Supreme Court, not also from the bench. Everyone, there's a lot of more organization this time round, and as they had correctly noted, already the Supreme Court on matters of technicality vacated their previous decision as regards Section 159(2). Other than that, I'd also like to recommend that the legal teams, they were more organized. You could see they were allocating time. Then by them also dividing their time, they could argue specific things as regards the petition. But if I was to talk on the petitioner's case, I would like to say that the petitioner's case was also more organized this time around, being led by senior counsel James Orengo. I think the major argument from my interpretation was that the elections were not held. NASA has taken an angle where that they are not challenging Uhuru Kenyatta's being declared, but they are trying to tell the court, look, wait a minute, elections were not validly held. And that's why you could see there was a lot of fuss to things to do with the statutory reforms, the verifiability, the accountability, and also things such as the results being announced without the 10,000 Form 34As being in custody of the IEBC. So I'd really like to laud NASA's case this time round. They are very specific on their issues, and also to look on the sovereignty of the people, where Wahungu was talking about Mutahi Kangu, sorry, Dr. Mutahi Kangu. Yeah, in that by the election being compromised as alleged is also an attack on the sovereignty of the people. Article 3 talks of the defense of the Constitution, and Article 1, the power being bestowed upon the people, and people only delegate, even to the judiciary, their power. So a lot more improvement this time round. And also from the other side, the respondents, they tried to also punch holes into the response from the petitioners. So it was quite uneventful.
All right, and well, this is Kivumbi 2017, and for those of us who'd like to continue on KTN News, you're welcome to do so, but on KTN Home, it's time for Life and Style, so it's time for us to release KTN Home and say goodbye. And well, when we come back from the break, we're going to be looking at what is expected and the importance of some of the